Innovation is taking two things that exist and putting them together in a new way. Good afternoon to everyone present over here. I am Monica of 2nd BSc Biochemistry. A warm greeting to Chairman N.R. Dhanapalan Sir, Secretary N.R.D. Prem Kumar Sir, Joint Secretary P.E.R. Premchand Sir, Principal Ma'am, Inita Lebanon FNC Vice Principal Ma'am, Jafia Solomon, and all the participants who have joined this program. And I'm profoundly delighted to take an opportunity to introduce our guest, Mrs. Latika Kaduja. And now I call upon Dr. Nadia Ma'am for giving brief note about IAC. Welcome.
Very warm welcome to all and all present here. See, now we are gathered for self-driven activity. It converts idea into profit-making assets. Innovation is the ability to see changes as well as opportunities, not a threat. Innovation is converting idea into new products, new process, as well as the services. So, Anna Violet Arts and Science College started an innovation through our Institution Innovation Council. They conducted the many activity like MIC driven activity, quarter one activity, and quarter two, quarter three, as well as quarter four. Other than that, they conducted celebration activity and self-driven activity, impact lectures. See, mostly they conducted the entrepreneurship program, like more than 15 program they conducted, as well as startup program around 10 they conducted. Celebration and startup activity they conducted 7. Innovation program is about 7. Celebration activity is around 2. Now they have started the quarter 4 activity. It is around 7. They are started and they are performing well. Now we are initiated the 2 more program added into the IAC portal. One is Kapila, another one is Yukti. It is main objective is about the startup as well as the framing the patent, as well as they are going to develop the innovation in the students as well as the institutions. The main objective of the Kapila is to recognize the facilities and facilitate the intellectual property as well as the innovation. So the Yukti 2.0 is initiative of MOE Innovation Cell and the All India Council for Technical Education. It is focused on creating a national database of technology and innovation. See, our IIC Council objective is make an innovation in our institute. So we need your support, including staff members as well as the students. We all together make the innovation council is a successful one. Thank you.
Small cheer and great welcome makes a merry feast. Now I call E. Ramya Ma'am, Assistant Professor, Department of Commerce General, for guest introduction.
Good afternoon to one and all present here. It's give me immense pleasure to welcome our chief guest, Mrs. Latika Kanduja ma'am, an entrepreneur of and founder of IP solution firm, IPLOEA and patent agent. She is graduate in BE Electronic and Instrumentation in North Cap University, LLB in CCS University. She is actively in providing intellectual property consultancy and end-to-end IP, supporting to startups and SMEs. Specifically, her area of experience includes identification and innovation consultancy, protecting innovation in form of patent, trademark design and copyright, planning IP strategy, litigation support, especially protecting SMEs from aggressive patent litigators, managing IP assets. Her specialty, she is having more than a decade of experience supporting startup and SMEs and even corporates in protecting their innovation and planning and executing their IP strategy. She is registered in Indian Patent Agent. She belongs to engineering background with specialization in electronics and instrumentation. She worked on technologies ranging from electronics, telecom, 5G, LTE, electronic, mechanical, automotive, and home appliances, semiconductors to medical imaging. Her experience, current role, she is a founder, director of IPLOEA. His company supported startup and SMEs in planning their IP strategy, protecting innovation and management IP assets, and providing support during IP litigation. Being the founder, she is responsible for all the activities and initiative taken in the company, starting from client reach out, marketing, solutioning, to handling operations like project scoping, quality checking, employee management, ensuring customer satisfaction. She is having a team focused on to provide the same experience and quality on every project. A prior experience, Calivolex Technological Specialist, May 2017 to April 2021, 4 years experience, and elusive practice expert October 2010 to May 2017. A specialty is to responsible for supporting in-house IP councils and attorney of SMEs and Fortune 500 companies in protecting innovation and planning IP strategies and managing monetizing IP assets and strengthening litigation arguments. It's given me immense pleasure to welcome our chief guest, ma'am. You are highly motivative and inspiring, and I am very much sure that you will be enlighten the young pillars of our society. I welcome you, ma'am, to address the gathering.
Thank you so much, ma'am, for introducing me and for giving this opportunity to connect with you all today. So, with that, I'll start the presentation. Allow me a minute. I'll just share my screen. I believe my screen is visible.
Yes,
Yep.
madam.
Thank you. So I'll start. So today we are going to discuss, as you all know, the agenda that we are going to discuss how to convert innovation ideas into profit-making assets. And before I move on to the main part of the topic presentation, I would like to take 2 minutes of your time to talk about a very interesting man here. That's Dr. Michael Doyle. I believe that most of you are not aware of this person, and that is why I'm taking this opportunity to talk about him today, to introduce this person today. So, who was he? He was an inventor or researcher like you and me in the University of California, and what he did, he invented a web browser that supported plugin, streaming media, and cloud computing. And he was intelligent enough and he was aware of importance of patents. That is why he filed patent application in 1990s to protect his innovation. And what happened next? He found that Microsoft, which is one of the biggest companies in the world, is using his patent protected technology in Internet Explorer. That is why Michael Doyle reached to Microsoft for licensing. And not only Microsoft, there were other companies also who were using, his patent protected technology. But specifically, we are discussing Microsoft here. So Microsoft, as I mentioned, that he reached to Microsoft for licensing, but Microsoft denied. Of course, nobody wants to pay money, right? So that is why Michael Doyle reached to US court and filed suit against Microsoft. and in return, he was awarded damages of $521 million. That's the power of patents. So as you can see, you can understand that he could have spent time only in improvising his product to make sure that it has more and more features, it is more user friendly. But since he actually took out time, right, and filed patents to protect his technology, that is why he earned such a huge amount of money. He might not have earned such a huge amount of money just by working on his technology without protecting, right? Next, Michael Doyle could be you, but only and only if you protect your idea today. Because if you do not protect your idea, then you will regret in future, because tomorrow someone else might just publish or protect the idea, and in that case you cannot do anything about it, right? So just do it today. Okay, so there are various ways that you can protect your ideas. Okay, or protect your thoughts, or anything, just to earn money. There are different ways to earn money, but today we are going to discuss few ways to earn that. Okay, so first point that we are going to discuss today is about patents. Okay, because patents are very very important in today's world, because this is specifically used to protect your idea. Okay, so let's understand first that what is a patent, and what are the different advantages of it and subsequent slides. Okay, so patent is a right that is given to a person over creation of his or her mind. Okay, it is mainly used to prevent others from making, using, offering for sale, selling, or importing the invention. Let's understand it in a very basic manner. Whenever you build a house, what do? You actually try to create a boundary around your house to say that, okay, inside this boundary, this is my property. This is my, I have the right on it. If you want to use it, then either take permission from me, right? Or give me money in return, like rent, right? Similarly, patents are also used to create boundary around your innovation, so that you can prevent others from using it, or doing anything about it. So in that case, you can say that if you want to use this technology or idea, then either take my permission or give me royalty in return, right? So this is why patent is used. Let's understand it more detail through some examples. These examples are very simple ones. Anyone can do it. It's not, I mean, specific domain is not required, I would say. It can be a very simple feature, it can be complex also. It's just that the idea has to be new. That's the only thing that we have to keep in mind. The idea should be new worldwide. Okay, so let's see some of the examples. You can think of a recommendation engine that recommends similar products to a user. So think of Amazon. So whenever you search on Amazon, after a certain period of time, Amazon starts giving recommendation to you that, okay, you might be interested in this product or that product, right? So that recommendation engine can be patentable. They are already being patented, but modifications are also can also be patented, right? Think of a social media platform that provides ads based on user profile. Think of autonomous vehicles. That's so much on news nowadays. Think of a recommendation engine that recommends specific route in going from one position to another. So it can be on the basis of course, the traffic, but other things as well. So that could be your specific preference, that I want to take specific route like this. Okay, think of web cameras in a application that is running on your phone, measuring tool, anything. Just look around you and you will find that there are different ideas that you can work upon to make it patentable, right? So as I mentioned that the only thing to get a patent is that the idea should be new. Okay, and it should not be obvious. So it shouldn't be like from um from one product you have taken one feature, from another product you have taken another feature, and you simply aggregated two. So it is not allowed, because that would be rejected based on the fact that the idea is obvious. Okay, so even though, let's say, your idea is new and it is not obvious, still there are certain categories in which you cannot get a patent. So I'll just give a brief overview about those, uh, so that you have it in mind that what all cannot be patented. Okay, frivolous inventions or inventions that are against natural laws cannot be patented. Okay, inventions contrary to morality. So that means if any invention can be harmful to animals, human being, or anyone else, cannot be patented. Okay. Similarly, discovery of a scientific principle or discovery of living on non-living thing per se cannot be patented, because it's a discovery, it's not an invention. Okay, so these cannot be patented. Method for doing agriculture or horticulture cannot be patented. So, but if you are coming up with a new device, new tool, new instrument for doing the agriculture, that can certainly be patented, but not the method. Okay, let's see some more categories around it. If you're coming up with a new form, okay, new property or use of a known substance, that cannot be patented. So, for example, if you are coming up with the fact that you know turmeric can be used to uh, you know treat coronavirus, then in that case it cannot be patented, because turmeric is a known substance and you are coming up with a new use of it. So that is why it cannot be patented. Okay, mere mixture of devices. Okay, you have simply mixed two elements, or and there were there is no improvement in efficacy, or there is no benefit, right? Then it cannot be patented. Similarly, mere rearrangement of devices, plants and animals per se, process of therapeutic treatment are, are, are those categories in which you cannot get a patent, even though it is new. Okay, okay. I hope it is clear. Now, moving on to the next point, which is very important, that why do we need to register a patent? Because if we do not understand this, there is no point in moving forward, because this is the topmost uh, important topic for this thing. So, first thing that why do we need to register patent is to stop anyone from copying your idea. Okay, of course, because that's your idea. You have put such a hard work on it. You do not want others to copy just like that, right? So that is why patents are used to stop others from stealing your ideas. Okay. Another reason for filing a patent application is that it can act as a source of revenue if licensed, right? So we have seen in case of Michael Doyle that how much money we have earned because of the license, or from Microsoft specifically, right? Similarly, you can also think of it as a source of revenue if you have licensed it or you want to license it, like that. Okay. Another reason for filing a patent application is to gain marketing edge and credibility. So you might have seen in case of various FMCG products that they actually write patent number on the product, or they actually write tag patent pending. So have you ever thought of it? I mean, why are they doing such things? It is basically to gain marketing edge over others, over their competitors. Okay, because if there are two products and let's say a person is going out for shopping and he sees that a number of bottles are lying on the shelf and he wants to buy a bottle, and on one bottle patent number is mentioned. And so in that case, the customer might think that since they have already got a patent on this, so that means the technology might be new, right? And hence the quality of this product might be better than rest of the products. And that is why it helps in gaining marketing edge over the competitors, right? Another very important reason for filing a patent application is to increase valuation of your company. So I was in discussion with various startups, and one of the main reasons why they want to file a patent application is to increase valuation of their company. So it can be two times, three times, 10 times, depending upon a lot of factors. And in fact, whenever they reach out to investors, okay, for funding, they also ask this question, whether your idea is patent protected or not. Of course, because they also want to invest in an idea or company whose idea is protected, so that nobody else can enter their domain easily, right? So these are some of the advantages of a patent. It is not that it is limited to these four, but there are various other advantages as well. But these are the topmost according to me. Okay. Now moving on to the next topic, which is what we have to do when we have any idea. Okay. So let's say if you have to earn money out of your idea, then what exactly you have to do? Okay. So first of all, reach out to your mentors or expert patent firm like me for guidance. Okay, and ensure that you do not disclose your idea in public, because if your idea is disclosed in public domain, then it is not new. It is not considered as new idea, even if it was published by you. Okay, that is why do not publish anything until you file the patent application. Okay, and ensure that whenever you discuss your idea with patent firm, please make sure that you sign NDA with them. Okay, and very importantly, you have to decide in which countries you want to patent your idea, because patents are territorial. Okay, so that means if you want to protect your idea only in India, then you have to file patent application in India. Okay. However, if you want to file, you want to protect your idea in, let's say, other countries as well. So, for example, US. Then in that case, you have to patent your idea in US as well. So it is not like you file a patent application in India and you get protection worldwide. So it doesn't work like that. You have to select those countries where you want to get the protection and file your patent applications accordingly. Okay, and there are timelines, very specific timelines that you have to keep in mind if you want to protect in multiple countries. So it is not like you file patent application in India today and 5 years later you want to protect your idea in, let's say, US. Then it is not possible. So there are specific timelines defined to move out of India, okay, and file the patent in different countries. I hope this is clear. Now, what so when you reach out to a patent firm, what they generally propose as next steps? Okay, so first of all, they can assist in checking whether the idea is patentable or not. Okay, so in this particular case, as I mentioned that the you can get a patent only and only if your idea is new worldwide, okay, or if the idea is not obvious, right? So in this particular step, the patent firm will conduct a search on their end to check whether this idea is disclosed in the public domain or not. Okay, and thereafter, they can help in applying for a provisional or non-provisional patent application. So let's understand the concept of provisional and non-provisional in subsequent slides. So provisional application. So as the name suggests, it's a preliminary application that may be filed when your invention is still evolving. Okay, so that means you have got the basic idea, but you are still working on it to improvise it, right? And you need some more time to complete it. Okay, so this provisional application will be used to protect your basic idea from day one. Okay, so that means they will you will get benefit of priority date if you file the provisional application. Okay, and so in a way you will get 12 months to complete or evolve your idea. Okay, so let's say you have got your basic idea today, protect it today, and work on it, and file the regular patent application within 12 months of filing the provisional patent application. Okay, and this is completely optional. Okay, it is not at all mandatory to go for the provisional application. If your idea is complete, then directly go for the non-provisional patent application. Okay, so as we discussed that non-provisional application, it's a formal application. Okay, that we need to file within 12 months of filing the provisional application. Okay, if you are not starting with the provisional application, then you can directly file the non-provisional application. There is no problem. Okay, and in fact we recommend that if your idea is complete, then start with the non-provisional application, because that will expedite the overall process. Okay, I hope this is clear. Okay, moving on. Let me just skip this part. Okay, so let's understand, you know now you know that what you have to do when you have got any idea. And now let's understand how we will how we can obtain a patent on your idea. Okay, so there are majorly, the steps are divided into 5 parts. Okay, I'll start with step number 1, which is optional but highly recommended one. Okay, so in this particular step, what we do is that we conduct a search, okay, a patentability search at our end, okay, to confirm whether your idea is new or not. Okay, so for example, if any researcher sitting in US has published the idea in a paper, right, like a research paper, then in that case you cannot get a patent on that, right? So then there is no point in moving forward and file a patent application. However, if the idea is partially disclosed, okay, then in that case, this step would help in determining the scope of patent application. That okay, this part is disclosed, but this the second part is not disclosed. So then we will emphasize on the second part of the idea to file the patent application, because we know that this is the new part, right? So this is the step number 1, in a way, is very essential, because it's like a preparation that we have done, that what all can be protected by means of this particular application. Okay, now the process moves to step number 2. In this particular step, based on the scope that we have decided in step number 1, we draft the patent application. Okay, so in this particular step, we need to you know write a very detailed description of your invention. Everything we have to describe, that what are the, let's say if you're coming up with a product, then in that case, what all components your product is having, how they are connected, how they are working, and different embodiments or different conditions in which it can work, and different input parameters or output parameters they are generating. Everything we need to explain in the patent application. Okay. And the commercial value of your patent mainly depends upon two factors. First is that, of course, about you, on your invention. Second is how the patent is drafted. Okay. So if the you know if the claims specifically are written in a very narrow format, then the commercial value will go down, right? And if they are very broad, then you will not get a patent on it. So that is why we have to understand, based on the search, that how we need to define the scope of patent application. And that is why uh, experienced patent attorney is very much required for drafting the patent application. Okay. Once a patent is drafted, we need to file it at patent office. So you need to, uh, you know, you need to first of all decide that where all you want to protect your idea, and based on that, we have to file the patent application at different patent office. So let's say if you want to protect your idea in India, then we will file the patent application at Indian patent office. Okay. I hope this is clear. Once the patent is filed, then it would be it would publish. Okay, the patent application will be published by the patent office within 18 months. So that is the standard route. So once you, let's say you file the patent application today, then within 18 months, your patent application will be published. So published means that it will come in the public domain, like in a journal it will come, and it will mention that it's your idea. Okay. So it is the standard route that I mentioned, but there are different other routes as well, in which you can publish your patent application uh, you know, before 18 months as well. Okay. So after this, the process moves to step number 4. Okay. So that means once the patent is published, then it moves to next step of examination. Okay. So once a patent is published, then it will enter the queue for examination. At this phase, examiner would look at your patent application to see that whether your idea is new or not, whether your idea is obvious or not, whether your idea is clear or not, okay, and other things as well. And based on that, he will generate one examination report, okay, and he will give it to us. Okay, so we need to uh, respond to that examination report to convince the controller that uh, that our idea is new. Okay, and hence please grant this patent application. Okay, there could be hearing as well. uh, you know you know it is like a face-to-face meeting with the controller, in which we have to convince the examiner that yes, our idea is new, and yes, our idea is obvious, and that is why we request you to please grant the patent to you. So if the examiner is convinced that yes, your idea is new, then he will grant the patent to you, right, at step number 5. However, if examiner or controller is not convinced, then in that case, he can also refuse the patent application. So it is not like you file the patent application and you will get it, right? So it is not like that. So it is completely based upon your invention, quality of the draft, and the examination process. So various things. Okay. I hope you got the process. Now moving on to next slide, which is specifically on the timelines. Okay, so this is, you can say, more or less a summary of what we have discussed along with the timelines. Okay, let's say if you start with the provisional application today, okay, which is optional. As I mentioned, there is no mandate that you have to start with the provisional application. You can directly start with the non-provisional application as well. Okay? But let's say if you start with the provisional application, you will get 12 months of time period to file a non-provisional patent application. Okay. Once a non-provisional is filed, then your patent application will be published in the public domain after 18 months. Okay, that's the standard route. But let's say if you want to publish it early, then you can take the expedited route, and in that case, your patent application will be published within a month. Okay, once a patent application is published, then it will enter the queue for examination. And in this, if the examiner is convinced that yes, your idea is new, then he will grant the patent to you. Okay, once it is granted, then it would the patent would expire 20 years from the date of filing. After this time, you cannot do anything about it. You cannot renew the patent, and so it is like it will come in the public domain, and anyone can use it without requesting for your permission. Okay, and once a patent is granted, you also have to pay renewal fee every year. Okay, to keep the patent active. Otherwise, if you do not pay the renewal fee, then it will be abandoned. Okay, I hope this is clear. Sorry. So that was all about patents. Now moving on to discuss how we can help you at in getting a patent. So first of all, we will provide free of cost ideation and innovation consultancy to you. So in this particular case, let's say if you have idea and you're not sure how to go about it, then we will provide free of cost consultancy to you. And let's say if you're coming up with a product, okay, any product, it could be a very simple product, and you're not sure what all features it can protect, then in that case, we will provide free of cost consultancy to you. We will dig down, we will dig deep into the product, and then to extract features that can be patented. Okay, and thereafter, we will also provide support in conducting a patentability search to check whether your idea is already published in the public domain or not, or how much is published, right? And based on that, we will draft a good quality patent application for you. And accordingly, we will file the patent application at different patent offices wherever you want to protect. Okay, and our support doesn't end there. We will also provide support in patent examination or prosecution stage as well, to make sure that you get a grant. We will try our best for that. And in some aspects, we provide support in patent commercialization as well. Okay, now that was all about patents. Now let's understand other ways to get money out of your ideas, or so there are broadly various types of intellectual property rights. Okay, patent is one of them. Okay, so other forms of IPR include, so patents that we discussed mainly protects functionality of your idea. Okay, and design is mainly to protect design of your 3D work. Okay, copyright is to protect creativity of your work, and trademark is to protect brand of your company. We'll discuss these things in subsequent slides. Patents we have covered. in previous slides, and now we will discuss overview of design, copyright, and trademark. Okay, so let's start with design. So design is mainly to protect outer appearance or ornamental features of a product. Okay, so you know this is only to protect the outer appearance. I'm emphasizing on this fact again because it is not for protecting functionality of your product. It's just the how it looks. Okay, and again it is used to prevent others from making, using, offering for sale, selling, or importing the product. Let's understand it using some examples. Whenever you see a new car in the market, the shape, the appearance of that car is already protected by means of design registration, because the brand owners do not want others to copy the outer appearance of that car, right? Because that's quite important, right? Let's see some more ideas or examples for design registration. Apple have also protected different features of their phone. Okay, specifically if I have to talk about design, Apple have also protected their design of having a circular home button at the downside, right? So that means no other company like BlackBerry or Oppo, no other company can have this circular shape at this position, because this is already protected by Apple. Okay, they can have any other shape, any other location, but not like this. Okay. Similarly, Apple have also protected the design of Apple Watch so that nobody can copy this. Okay. Now let's understand copyright. Copyright is another form of IPR, that is intellectual property rights, and it is mainly to protect authors' work like books, poems, plays, songs, films, and artwork. And it is mainly to stop others from using authors' original work. Okay, so you might have seen, actually, uh, in most of the works, it is mentioned that it was copyrighted. Okay, in photographs also it is copyrighted. So these are some of the examples that we discussed, that if you have written any book, if you have created a painting and you do not want others to make similar paintings, then you go for copyright. If you have written lyrics of a song or poem, let's say, then you go for copyright. Let's say if you have created a cartoon, designed a cartoon, then you can go for copyright. Photographs as well, photography, everything comes under copyright, because that is to protect creativity. Okay, now moving on to discuss last form of IPR, that is trademark. Okay, trademark, you might have seen hundreds of trademarks per day. You are actually looking at hundreds of trademarks per day, but you are not realizing it. So trademark is nothing but a sign. It's a logo, tagline, expression that distinguishes goods and services of one company from another. Okay, it is mainly to protect brand of a company. So, for example, this is a trademark of Coca-Cola, and this is a trademark of Pepsi. So, what it is used for? So, it is mainly to say that to differentiate or to distinguish the soft drinks prepared by Coca-Cola from soft drinks prepared by Pepsi. So that means Coca-Cola cannot manufacture or sell Pepsi under their name, and vice versa, right? So in a way, it is mainly to protect brand of a company. Okay. So before I move on, I would like to say that whenever you are coming up with a product, okay, you have to first of all understand that what all features you want to protect, and based on that select the IPR. So for example, very simple example, very very simple. Let's say if you are coming up with a uh, new machine to clean the floor, okay, an automated floor cleaning machine, you can say, okay. So you need to first of all understand that what all you want to protect for that, okay. So since it is an automated machine, so of course you want to protect the functionality of your idea, okay. So that means you need patent to protect it first of all, right? If let's say that machine is can easily clean the corners as well, so in that case the design of that machine might also be new, right? So in that case you need design registration as well, okay. Thirdly, of course, you want to protect, you will also give a name to that machine, and you want to protect that name so that others cannot use the same name, right? So in that case you go for trademark. So that means for a single machine you at least want these three, and there can be multiple features for patent applications, so that means multiple patent applications might be required, right? So if you want to protect your idea from different perspective, you have to be very thorough with that, and you have to understand that how you will protect different features of that machine, okay. So with that, I would like to thank you all for joining today's session, and I hope you found it useful. If you want to know more about patents, then please follow IP Lawyer on LinkedIn. You can also visit us at www.iplawyer.com. You can also email us at info@iplawyer.com. In case of any queries, please feel free to call me at 9811 or 9810328796, and we will definitely assist you in getting part. Okay, so thank you so much. Let me stop sharing.
Thank you, ma'am. We have a questions. How long it will take to get patent, ma'am?
So in this case, ma'am, if let's say we are going through a regular route, okay, we are not expediting any of the routes, uh, then on a trend analysis, you know, I would say that it will take uh, 2 to 4 years from
Two
the
to
date of
four
filing
years.
the patent application. But let's say if you expedite all the processes, then you can get the patent as early as 6 months or 1 year as well. So that depends upon a lot of factors, uh, but it can be like 6 months also, as early as 6 months, or it can be like 4 years as well.
Okay, ma'am. If any fast process is there to get the patent firstly before 4 years.
Yes, ma'am. So first of all, I've mentioned that first of all, regarding the publication, there is a process for early publication. So in that case, your patent, which was generally published in 18 months, now will be published within 1 month. Okay, it's actually 2 weeks, 1 or 2 weeks actually, but on a safer side, I would say that it is like 1 month. And if you are eligible for expediting the examination process as well, because there are certain criteria who can actually expedite it. And if you are eligible and you're falling under those categories, then in that case you can expedite the examination, and in that case you can get the first examination report maybe in 3 to 4 months, or maybe before that also. So that depends, a lot of factors which are not under our control. So it is like bandwidth of patent office and everything.
Okay, ma'am. Actually, see, if we are file the patent means, then we will can make a product as well as we will market it that product itself, or else after getting the copyright only we have to market that one.
So as soon as you file the patent application, you can start doing, marketing or do anything about it. So we just have to file the patent application. We don't have to wait for the grant, and we can start marketing and whatever we want to
Okay.
do.
Okay. So it is a very useful topic for us as well as our students, ma'am. Thank you so much, ma'am, for joining with us. It's my pleasure to render my thanks to my chairman, sir, N.R. Dhanabalan, sir, and secretary, sir, Prem Kumar, sir, and our joint secretary, sir, Prem Chand, sir. And also, I have to thank our principal ma'am and vice principal ma'am for their support. They are motivating us to continuously for us for a new innovation in our IAC council. And I must thanks our speaker, Ma'am Latika Ma'am. Thank you so much. See, then only they will we will initiate our patent process hereafter. It is very useful topic to us as well as our students. Thank you, Ma'am. And also you explain about the progress, provisional and non-provisional patent type and all. That is a very informative one. And also, you say about the process of filing the patents. First, you should not share your ideas with your colleagues or anybody else. That is a very, very important one, ma'am. And then how we have to apply the patent in the patent office and how we have to do the application process. It is very important one. Thank you so much, ma'am, for joining.